Suspicious activity reports, or SARs, can be submitted by any organisation or individual who knows or suspects that another organisation or individual is engaged in money laundering or terrorist financing. Every SAR submitted to the UKFIU must clearly set out both the reason for the suspicion and the criminal or terrorist property to which the suspicion relates. If you are seeking a defence against money laundering or a terrorist financing offence, the SAR must also clearly set out the prohibited act that you wish to carry out. Omitting any of these three criteria from your DAML or DATF SARs, or failing to clearly describe any of these three elements, may result in you receiving a further request for information. These requests can cause delays to the UKFIU and law enforcement in reaching a decision on your request. In this video, we will discuss best practice for completing the criminal or terrorist property element of your SAR. See our other videos and guidance to find out more about completing the reason for suspicion section and information to include about the prohibited act. Under the Proceeds of Crime Act, criminal property is any property that constitutes or represents a benefit from criminal conduct if the alleged offender knows or suspects that it constitutes or represents such a benefit. Conduct is considered criminal if it constitutes an offence in any part of the United Kingdom or would constitute an offence in the United Kingdom if it occurred here. Under the Terrorism Act, terrorist property is any money or other property that is likely to be used for the purposes of terrorism, is proceeds of the commission of acts of terrorism, or proceeds of acts carried out for the purposes of terrorism. It is important to understand the legal concept of fungibility, which may result in a relatively small amount of criminal property tainting the whole of an asset. If you are unsure about how this applies to your situation, you should seek legal or regulatory advice. In order to request a DAML, or Defence Against Money Laundering, the criminal property must already be in existence at the time you submit your SAR. You cannot seek a DAML if you believe the property will become criminal property once the activity you're seeking a defence for has taken place. This would be seeking a defence to carry out criminal conduct, and there is no provision to permit this under the Proceeds of Crime Act, and the NCA is not able to make a decision in these cases. If you're not sure about this point of law, seek legal advice. In contrast, both criminal and clean funds are used to fund terrorism. So, if you're requesting a defence against terrorist financing, it is important to consider both the intended usage of the funds as well as their source. When completing your SAR, it's really important that you identify as clearly as possible what the criminal or terrorist property is. You should include the value of the property if you know it, and also ensure you identify the reasons you have for suspecting the property is criminal or terrorist property. You should also include the whereabouts of the property or provide any information you have to assist in identifying the whereabouts of the property.
The UKFIU provides a wide range of guidance and information about the suspicious activity reporting regime, all of which is available on the NCA website. We regularly publish our SARs in Action magazine with articles and sanitised case studies about the importance and impact of SARs, while the UKFIU podcast covers key areas of interest with input from experts across the sectors. Follow us on LinkedIn and X to be kept up to date when new guidance materials, magazines or podcasts are available.
The UKFIU's reporter engagement team offers one-to-one feedback sessions, presentations and workshops for reporters across regulated sectors. Get in touch to find out how we can work with you to improve the quality of SARs reporting and protect the public from serious and organised crime.